As it was already mentioned in the introduction, I am a human rights officer in the Ministry of Human Resources in Budapest, in the Family Policy Department. So today I am here in this capacity of mine, but be assured that I would also be here in my civilian capacity if I wasn't sent by my ministry. And I am here today in order to share with you some recent developments from my country as far as the protection of life and families is concerned. In the first part of my speech, I will be addressing the background and the life-related values of appearing in the new Constitution of Hungary, which I sometimes will call the fundamental law, but it means exactly the same thing as the Constitution. This is the Constitution that came into effect on the 1st of January this year. The second thing I will be addressing is the law on the protection of families. Both of these legal instruments have been extensively criticized at various levels and for various reasons, ranging from making reference to Christianity or protecting the right to life and human dignity from the moment of conception, all the way until the protection of marriage as the union of one man and one woman. The conclusion that I will draw is that contrary to what one might think about the new fundamental law and the law on the protection of families, they are not revolutionary at all. These are legal instruments that are rooted in European and international legal standards that are absolutely and universally accepted. In the second and last part of my speech, I will try to address some concrete measures that the government has made in order to introduce the protection of life and families in Hungary. So the first topic is the background of the fundamental law of Hungary, which should be examined in a context. It cannot be examined in a clinical isolation, but should be looked at in the Hungarian context, in the Hungarian reality, which on the one hand is an alerting demographic situation. We have very low fertility rates and the number of marriages is on the decrease. It is not a uniquely Hungarian problem, I guess. It might sound very familiar to most of you, but this has to be stated when we talk about the background and context of the fundamental law. Also, the total population of Hungary has decreased under the psychological limit of 10 million people, and the economy is severely affected by the crisis. In this situation, the state has a primary duty to protect the families, to protect life. This obligation is not merely a moral obligation, but stems from international legal standards and instruments too, as we will see. The fundamental law of Hungary came into effect on the 1st of January this year, but the need for a new constitution had emerged well before. Hungary, after the change of the regime, was one of the rare countries that did not enact a new constitution in 1989-1990. We kept our Soviet-time constitution, and although it was amended several times in 1989 and later on too, the desire for a new constitution lived on. But no political formation had an enough mandate in the parliament to enact a new constitution. After the change of the regime, many governments were following each other, and that is how we arrived to the year 2010, when our current government was elected, led by Prime Minister Viktor Orbán. The present government is a coalition of two parties, the Hungarian Civic Union and the Christian Democrats. They were both determined from the beginning to enact a new constitution. A very extensive public consultation started. And to mention just one result of this, a record number of questionnaires came back to the government, namely close to 1 million questionnaires came back, which is an extremely high number, taking into account that it is a public questionnaire. To make a long story short, the new fundamental law of Hungary was enacted on Easter Monday, 2011, and came into effect on 1st of January, as it has already been mentioned. The new fundamental law lays down principles and values that I will not spend much time on, but it includes the rejection of National Socialism and communism, including, among others, as two dictatorships that the country has experienced through the 20th century. It also lays down the principle of the cooperation between church and state, which all these topics could be addressed in their own rights, but for the sake of the present speech, I will focus on life and family-related aspects with a brief introduction about Christianity, on how the Christian values appear in the fundamental law of Hungary. The new fundamental law reaffirms the Christian values which support the Hungarian state and society. It makes reference to Christianity twice in the preamble as follows. The first reference says, "We are proud that our King Saint Stephen built the Hungarian state on solid ground and made our country a part of Christian Europe 1,000 years ago." The second sentence says that we recognize the role of Christianity in preserving nationhood. We value the various religious traditions of our country. These two references are probably the ones that have triggered the most heavy criticisms. However, if we look at the standards of European public law, we can see that a number of states also make reference and acknowledge Christian values as fundamental to their societies. For example, the preamble of the Constitution of Ireland states, "In the name of the Most Holy Trinity, from whom is all authority and to whom, as our final end, all actions, both of men and states, must be referred, we, the people of Eire, humbly acknowledging all our obligations to our divine Lord, Jesus Christ, who sustained our fathers through centuries of trial." Bulgaria and Greece are no exceptions either to having constitutions making reference to Christianity. Eastern Orthodox Christianity shall be considered the traditional religion in the Republic of Bulgaria. The Greek constitution says the prevailing religion in Greece is that of the Eastern Orthodox Church of Christ. The Orthodox Church of Greece, acknowledging our Lord Jesus Christ as its head, is inseparably united in doctrine with the great Church of Christ in Constantinople and with every other Church of Christ of the same doctrine, observing unwaveringly, as they do, the holy apostolic and synodal canons and sacred traditions. Talking about European law standards, what the Hungarian Constitution is doing is merely following the spirit of the Statute of the Council of Europe, which states, reaffirming their devotion to the spiritual and moral values, which are the common heritage of their peoples and the true source of individual freedom, political liberty, and the rule of law, principles which form the basis of all genuine democracy. Besides that, the Treaty of Lisbon, establishing the European Union, also makes reference to religious inheritance of Europe. Now, I would like to talk about the protection of life since conception article in our new fundamental law. Article 2 of the fundamental law states that human dignity shall be inviolable. Every human being shall have the right to life and human dignity. Embryonic and fetal life shall be subject to protection from the moment of conception. Regarding this issue, a fervent debate also took place. However, if we look at international standards, we can clearly see that there is no standard that would contradict this article. Article 2 of the European Convention on Human Rights states that everyone's right to life shall be protected by law. The European Court of Human Rights has never ruled that the unborn shall not benefit from this protection. On the contrary, states have the right to decide when the right to life starts. To bring in another international instrument, I would like to quote the preamble of the United Nations Convention on the Rights of the Child, which states that the child, by reason of his physical and mental immaturity, needs special safeguards and care, including legal protection before as well as after birth. Marriage is protected under the new fundamental law of Hungary also. Article L of the new fundamental law stipulates that Hungary shall protect the institution of marriage as the union of a man and a woman, established by voluntary decision, and the family as the basis of the nation's survival. Hungary shall encourage the commitment to have children. The protection of families shall be regulated by a cardinal act. This cardinal act is the protection on the law, is the law on the protection of families, which I will be addressing later. Taking the Polish example is exemplary to us as well, where the constitution stipulates that marriage, being a union of a man and a woman, as well as the family, motherhood and parenthood, shall be placed under the protection and care of the Republic of Poland. Ukrainian and Latvian constitutions also contain similar provisions. Not only is the stipulation about marriage in line with other European constitutions, but it also reflects international documents. Among others, the UN International Covenant on Civil and Political Rights, in its Article 23, stipulates that the family is the natural and fundamental group unit of society and is entitled to protection by society and the state. The right of men and women of marriageable age to marry and to found a family shall be recognized. Having said this, and taking into consideration the fact that an overwhelming majority of the Council of Europe member states recognize the right to marriage between a man and a woman only, that is 39 countries out of 47, the Hungarian fundamental law is not innovative in this sense either. Now I move on to the law on the protection of families that was enacted on the 23rd of December 2011. Here I would kindly draw your attention to the fact that the Constitution was enacted at Easter and the law on the protection of families was enacted at Christmas 2011. The objective of this law is to create a predictable and safe regulatory environment for family protection and the promotion of family welfare, and to enforce the fundamental law. The law on the protection of families starts with the following two sentences. The family is an autonomous community established in human history before the emergence of law and the state, which rests on moral grounds. The second sentence says, the family is the most important national resource of Hungary. As the basic unit of society, the family is the guarantee for the nation's survival and the natural environment of the development of human personality, which must be respected by the state. As we can see, the law clearly acknowledges the nature of the family being rooted in natural law, and the state merely recognizes this fact. It is difficult to argue anything against this introduction of the law, as it reflects what the Universal Declaration states in Article 16. The family is the natural and fundamental group unit of society and is entitled to protection by society and the state. Numerous other human rights instruments reflect this principle, including the ones mentioned here, among others, the ICCPR, ESCR, European Social Charter, and so on. A main principle of the law is the primary responsibility of parents in the education of their children. This principle is also in accordance with international instruments. Another principle is the interest of the child. Last but not least, another principle is the protection of the unborn child. The European Court has repeatedly admitted that protecting the unborn child was not only legitimate, but also necessary. The law provides for a family-friendly approach in all fields of social and economic life. We can call it family mainstreaming, mainstreaming a family perspective in all areas of social and economic life. In Article 5, one area is explicitly mentioned, namely that of the media. The preamble names the stakeholders in this task. The state, local autonomies, civil sector, and the churches are also mentioned. The family is based on the marriage of a man and a woman. This is a principle that is laid down in the fundamental law also, and that has been accepted by the Venice Commission too. This principle, however, does not discriminate against same-sex couples. It merely gives them a different status. According to a ruling of the European Court of Human Rights, As it is the legitimate aim for the state to protect the family, some benefits can be limited to married couples only. Employment is another issue addressed by the law on the protection of families. It aims at giving tools in order to better reconcile work and family life. It provides for allowances for pregnant mothers and parents who bring up minors in various circumstances. Now, I would like to move to the second and the last part of my presentation today regarding the concrete measures. First of all, I would like to address the question of abortion in Hungary, which is not on this slide, but it is imperative to talk about that too. The number of abortions in Hungary is about 38,000 per year, with a population of 10 million people, which is a very high number, although it is on the decrease for several years, especially if we compare it to the peak in the beginning of the 70s when it was exceeding 200,000. We can see a considerable decrease, but there is still a lot to be done. The question emerges whether the new constitution will bring considerable change to that or not. Here I would like to recall Professor Saunders, who said that in order to protect life, we must be as explicit as possible in the law. Well, the Constitution is quite explicit when it protects embryonic and fetal life since the moment of conception. However, if we look at the wording more closely, it does not say that human life starts at conception. Still, we do think that it is a very big step forward, and it can be used as a very handy legal instrument for the protection of life. However, how it will be interpreted by the courts, and especially by the Constitutional Court, is something to be seen. Also, the government thinks that the protection of life starts with the protection of families, the families where the newborn will come into being. Therefore, a series of measures have been implemented in order to have a reliable, predictable family protection system. To mention just a few, tax allowances after the number of children have been broadened extensively. Previously, it was only after the third child. Now, it is also available for families with 1 or 2 children at a different scale, though. A very big topic is the reconciliation of work and family life for women. Therefore, atypical, flexible working conditions have been introduced. Employer receives tax incentive when employing a young mother part-time who is returning after the maternity leave. The new labor code that came into effect also on the 1st of January this year gives the employee the right to ask for part-time employment until the age of 3 of the child. The family allowance system has also been reformed. Somehow difficult to follow family allowance system was divided into 2, including an educational allowance part, which is very important for some parts of society where the education of the children was not completely guaranteed. It gives incentive and motivation for the parents to send their children to school. Stricter legal requirements to change laws on family policy have been installed as well. Therefore, the predictability and stability of the family protection system was broadened. We also talked about the economic crisis already. A so-called national estate incorporated was established in 2011 in order to help families with a mortgage burden and threatened to lose their estate. I would like to attire the attention to the family protecting stipulations of the labor code, on the law on the protection of the child, all this in the name of family mainstreaming. All in all, we can say that the issues that are considered that were considered, or that still are sometimes considered, to be controversial in the Hungarian fundamental law and in the law on the protection of families, from a politically correctness point of view, are absolutely in line with European and international law and legal traditions. And their criticism is unfounded at the best, or suggesting the agenda of a postmodernist pressure at worst. Well, this concludes the last part of my speech, and let me end by quoting another sentence from the preamble of the fundamental law of Hungary, regarding which exactly are the principles that can hold us together in our belief, what can hold a nation together. It says, "We hold that the family and the nation constitute the principal framework of our coexistence, and that our fundamental cohesive values are fidelity, faith, and love." Thank you very much for your attention.